G'day everyone, and welcome to video 3.2.10 for the Legal Studies guide. No quote today, just jumping straight into it. Hopefully going to be a pretty quick one because we should be well across the concept of costs and time already. It's something that's littered throughout everything else that we do. So yeah, no inspiration for you other than just get out and do it. You're obviously doing study if you're watching this video. So that's the first step. Good work. We are going to, look at the impact of costs and time on the ability of the civil justice system to achieve the principles of justice, which we know are fairness, equality, and access. So we'll spend a little bit of extra time on that last table, like always, because we do need to be able to connect all of these points to, fairness, equality, and access. But cost and time, particularly, it's going to be stuff that we've often already talked about, and just in a way, a bit of a review of the other key knowledge points. So, what impact do cost and time have on the principles of justice? Let's have a look. So, look, every other point we've done, we've been harping on this idea of court is very expensive. If you've already watched, you should have watched 3.2.9 where we talk about, factors and appropriateness of institutions like CAV and VCAT. And a lot of that centers around the fact that ideally CAV and VCAT aren't going to cost you as much. CAV is free, obviously, which really drives home that idea of taking something to court is very expensive. It's looking at civil disputes as a whole. So whilst a lot of this, what I'm going to talk about here, is going to focus heavily on the courts, it is worth noting that there are obviously costs at VCAT. They are just lower generally than the courts, but you might need legal representation there as well. You might go for advice from a lawyer and have to pay for that before you even consider initiating a dispute somewhere. So the costs can come from lots of different locations. Legal representation is that big one, and the cost, as I said, can start even before your dispute is initiated in the initial advice stage from a lawyer. It could include a lawyer contacting the other party via letter with a letter of demand, for example, trying to ideally resolve the dispute before you even have to initiate something. But even these things are going to cost you. So we know that lawyers, solicitors, so law firms that you go to are likely to be charging you for their work in 6-minute blocks. This is particularly large scale law firms. You might have different, you might have fixed costs, particularly in some smaller law firms or regional law firms, where they have fixed costs for a certain service that they're providing. But often larger law firms will be charging you for their work in 6-minute blocks. And depending on who's doing the work, that could be 200 at a minimum up to $800+ an hour. So that 6-minute block costing you somewhere between $20 and $80. The whole idea here is obviously that people who are working for these law firms and earning generally decent wages, entry level law wage isn't super by any stretch. It's the idea of there's progression, but you're earning around that median wage. Hopefully, the law firm is trying to get more money off clients than they're paying the employee naturally. So they're going to want the employee to be doing work as much as possible, and they want the employee to be able to charge that work out in 6-minute increments. If you then end up initiating a claim, particularly through the courts, and you end up going to court and deciding that you then want a barrister to present your case, that barrister is going to cost you up to perhaps $1,000 a day or even more. And that's on top of the fees that you have to pay the courts for those days. Rebel Wilson's defamation matter, she obviously had a very high-powered, expensive lawyer as a famous actress. He was supposedly charging $9,000 a day, I think it was. So think about, $9,000. Imagine if you had $9,000 right now, and that's what her barrister was getting for one day of work. We've got to be careful because I'm obviously giving you examples at the extreme end to illustrate how costs can quickly build up. They're not always going to be this extreme, but that central tenet does hold true that legal representation is expensive and as a result not accessible for everyone, and that idea of access is going to come up repeatedly. You've then got the court fees themselves, so sort of separate to legal representation. And I'll give you an example at the end here of what the fees are like, say, in the county court. But high fees and ongoing fees. You've got to pay to commence the dispute. Then you've got to pay different application fees, and you've got to pay for setting down a trial date, and then you've got to actually pay if you have a trial for all the days that you have. Every time you want to, request documents from the other party, you've got to pay for a subpoena. These things add up really quickly, and that's one of the really big points we say about VCAT is that VCAT doesn't have these ongoing fees. You might have to pay for, say, access to mediation through VCAT, but generally generally VCAT is a one-off fee, as opposed to the ongoing fees that the courts have. And filing a dispute in the Supreme Court can cost over $1,000 just literally to hand in the paperwork. Not to mention the lawyer you've paid to draft the paperwork. Um, we're going to talk about delays in a moment, but then the process is so long, obviously, that it adds to the above cost. There's all these pre-trial. If you do go to again, this is sort of really centering on the idea of going to the courts. If you do go to the courts, you're going to have pre-trial procedures like discovery, directions, hearings, um, you know, exchange of documents. All that sort of stuff is going to add more work, and that's work that needs to be done by lawyers generally, and that's cost again. So the longer the delays, all the steps in the process that are designed to provide more fairness, and equality, remove disparity, disadvantage between the parties, actually can add cost, which can then exacerbate those things. So really, really challenging. Look, time. Um, this is a bit of an older stat, and it's probably a bit lower now, particularly post-COVID. And I've got some data later on just to quickly show you on the next slide. But I'd say it's probably down to about 75% of matters are resolved within what are considered acceptable timeframes. But that still leaves a quarter of matters that are resolved outside of acceptable timeframes, and I'll show you what acceptable timeframes are for each court shortly. Look, the court process is long. If you, again, go to court, you do have other options like VCAT and CAV. We know VCAT is having increased delays, though. VCAT's really good to go to their website and you can click each type of dispute and it will tell you how long until you get a hearing. So you can get that information for lots of different lists. And I won't give you clear figures because tenancy disputes that are much more urgent around repairs and stuff at VCAT, they can be heard in days, whereas there's other disputes now that are taking 12 plus months to be heard at VCAT. So worthwhile having an individual look at different lists at VCAT. But particularly courts, those processes that I spoke about a minute ago can take really, really long and add time. Discovery is an example of that. Discovery is that exchange of evidence between the parties, where you're requesting branches of documents from the other party to look through and see if there's anything that helps you with the claims that you're making. And parties can actually abuse that process, like they can repeatedly request or try and extend deadlines and say that they need more time to look through things and request maybe more documents than they need, knowing that it will add delays, or vice versa, give the other party more documents than they have to, knowing that it will take the other party longer to look through them and driving up those costs. And that's something that is a bit of a tactic sometimes from parties that maybe have greater resources and therefore exacerbate disadvantage in a civil process. Obviously, that would be breaching overarching obligations if we remember key personnel, but it is I guess, a factor that needs to be thought about. It's not all clean and honest fun in the legal sector, that's for sure. Case management, judges, we've talked about that with roles of key personnel. Judges do have significant case management powers, and a lot of that is around in the court system, trying to limit some of these delays and put caps on things. But the reason why judges have been given those powers is because it is an issue. So that's worth noting. And that increasing load on the justice system and the delays that came out of COVID have just increased the amount of time it takes to get justice, which is a concern for fairness, equality, and access. Just got some data here, just to quickly show you. So this is the magistrates court, this top one. This is the county, and this is the Supreme. Just important, so both these are the Supreme. Just important because, like with costs, we sometimes give you the really egregious examples at the top end, without giving you good context of not every dispute is one that is going to take years and years to resolve. Not every dispute is one that's going to, end up with $2.85 million in legal fees, like one of the class actions I mentioned. There are a lot more disputes in the middle ground that get resolved in the time that they're meant to. So if we look at the magistrates court, for example, this is a nice little figure here. So 70% of defended claims in the magistrates court are resolved or finalised within 6 months. So that's pretty good. And there's only 183 cases at the time of that report in the magistrates court that have been pending for over 12 months. Which means we're pretty much resolving every matter in the magistrates court well under a year, and more often than not, less than 6 months. So the average time in the magistrates court to a resolution of a defended claim is probably less than 6 months, which is a really give some context around, again, the extreme examples we look at where it takes years. It is worth noting that only about a quarter of claims in the magistrates court are defended. So of all the claims filed in the magistrates court under $100,000, only a quarter of them actually get defended at a hearing. The other 3/4 are resolved either through a default order against the defendant, meaning that the defendant never responded and got an order made against them, or they just lapse and they're dismissed. And why they've probably lapsed is because the parties have, after the case is initiated in the magistrates court, we assume the parties have probably come to their own agreement and they've just let the dispute lapse because they don't need the court anymore. So that's also an important point around, alternative resolution methods and using things like mediation, arbitration services, and just simply negotiation between the parties to try and get a more timely resolution, which promotes the principles of justice. So, moral of the story, not a lot of defended matters in the magistrates court, only about a quarter, and then of those, all resolved in around 6 months. County court, we're talking a bit longer. So 2 main lists in the county court are the common law division and the commercial division, and they're resolving between them around just over half, 55% to 65% within 12 months. So again, we can probably draw a bit of a bow here and say, probably taking somewhere between, over half are getting done in 12 months. I can't imagine there's many go on the other side. So the average is probably going to spit out around that, around 12 months, maybe a little bit under in the magistrate and the county court. So if you file a dispute there, it's going to take about a year, maybe a bit less. That's still quite a significant amount of time. Think about where you're going to be in, say, April next year. A year's a long time to have a case going, but maybe not as extreme as, again, some of the examples we talk about where it takes years and years. And then the Supreme Court lifts probably to another level again, or it's actually probably pretty similar. Common law division, they're resolving 50% of cases within 12 months, but in the commercial court, 74% are clearing or finalising within 12 months. And a lot of this could be parties coming to their own agreement as well. And pretty much everything in the commercial court is within 2 years, and 80% are within 2 years in the common law division. So again, drawing loose bows, we could say that you're probably waiting 12 to 18 months on average in the Supreme Court. So 6 months in the magistrates court, 12 in the county, and 12 to 18 in the Supreme Court. So just to have some good data backing up what you're doing with time and then the costs that come from that, as opposed to just loosely being like, things in the court take years. This probably is a bit more correct. It's not a bit more correct. It is more correct because these are the facts. We have to discuss the impact of costs and time on the principles of justice, which means, obviously, we need to look at both sides and evaluate how much of an impact costs and time have on the principles of justice. And I've just got some good points in here around, we already know that most of the costs are going to fees and to legal representation. And we know that legal representation and legal practitioners are actually helping us achieve fairness. So there is a good side to the costs. We can't forget that. And that's putting parties on the same footing as well. And we know that it's going to help you be more informed. And if you're more informed, you are therefore more engaged, which is access. So the costs are helping us get the principles of justice. Obviously, the costs that go into all the court fees, the processes there are very much, and the strong rules are very much built around not ensuring there's no disadvantage, disparity, ensuring that we get the right outcome as well. Any delays as well should be all about finding the right evidence and making sure we get the right outcome. So costs are giving us good things. Delays and time taken are giving us good things. It's obviously the fact that they're having a negative impact as well that is important to understand. And it's ultimately up to you as an individual to make that evaluation. Do you think the costs are too extreme, even though we're getting this level of evaluation, even though we're getting something good out of it? Should there be more things in place to try and limit costs, for example? Should we resolve things quicker, even if it might mean that we rush a little bit and could impact the outcome? That's the level of thinking that this subject is hoping you're able to do and put into an answer. Um, Costs can lead to a wrong person being unable to pursue a claim. Delays can add to that. If you can't pursue a claim, you don't have justice. You can't engage in the system, which is also access. And just disadvantage. Like if the other party's got more money and you can't afford the same, I guess, quality of legal team, but quantity of legal team, like the same number of lawyers, you're just probably going to be at a disadvantage. And could justice then go to the highest payer and not the actual correct outcome? And that's a challenge in our system. So these are things to consider, and consider those both sides of the equation as we need to do. I've included this link here. It's in the comments below to the fee schedule in the county court, just to give you a bit more context on that. Again, here's a couple of screen grabs straight off that. For example, if you were just a standard regular individual without a concession card or anything like that, it's going to cost you $780 to file paperwork, not to mention the legal fees that have gone into the preparation of that. So already nearly $1,000 straight off the bat, plus paying someone to prepare those legal documents for you. If then there's all these different application fees. You might want an immediate injunction. You've got to pay, through the pre-trial stage. You've got to pay for. You might want to bring someone in for an oral examination. You might want to subpoena someone for documents. So you pay for each of these things as they're going, and then say all of that happens. You do some mediation, you pay for that. You can't resolve the dispute, and you end up having to go to a trial. Then you've got to pay $700 just to get dates for the trial, and then $560 for the first day. If you need more days, it's up to $800. We're adding up here. So say a 4-day trial is, quick maths off the top of my head, 4-day trial is going to cost you about $3,700 plus the $800 you've paid to start it and every fee on top of that. So once that adds up, plus the fees that you're paying the lawyers, justice can be a rich man's game, which we know is then fundamentally not access. Hopefully you are well across the impact of costs and time on the principles of justice as a result of this. But throughout, you're already considering why we use things like other methods like mediation, conciliation, and arbitration, why we have avenues or institutions available like CAV and VCAT, and why class actions exist for large group proceedings. All things that are trying to promote the principles of justice, because there is an awareness in the system that costs and time are a problem. So a little bit in this set of slides, obviously, but trying to make sure you're thinking about the broader picture of how the entire unit connects together in regards to these issues. Comments and feedback below as always, but yeah, happy